Hi, everyone. Harry here, talking about a potential big new move by the federal government in their ongoing battles with universities, especially elite universities whom they allege have been improperly, unlawfully, that's part of the issue, influenced by race conscious admissions policies, diversity in their academic viewpoints and their curriculum. Okay, Colombia. It already has been playing ball with the administration. It's in the position of the Paul Weisses here in the law firm world, as opposed to Harvard and Princeton, who've come out of the box saying, we are not surrendering academic independence and integrity. But the administration, whether or not Colombia realizes it, is proposing a big, much more intrusive arrangement. The arrangement is a consent decree, and there's a very well-established precedent for this that the federal government, the Civil Rights Division of the Department of Justice, to be more precise, often has used in the past to get at police departments whom they have found have a pattern and practice of unlawful, unconstitutional activities. So this is their tool of choice for a rotten police department, which, exists in hopefully rare and rare form, but the department finds, nevertheless, even in this day and age, on occasion. What happens? The government does a big investigation, doesn't look as if that's happened yet with Colombia, and makes these findings and presents a consent decree, which is a way of resolving a lawsuit, but not quickly. So it basically tells the municipality, say that has the police department, sign right here and agree to do these 25 things, like training your officers and having videotapes and those things that the Constitution doesn't require, but you are initiating because of these problems that you're admitting. And then that decree, without any kind of a separate adjudication, goes to a court to oversee. And these can sometimes be overseen for years or more. One of these actually was in place in Pittsburgh, about the Pittsburgh Police Department, when I became U.S. Attorney. And when I went to meet the mayor, basically to introduce myself to him, there are different ways you work with the mayor. Before saying hi to me, he said, "You've got to get this consent decree off our necks." It's another way of saying that for a lot of municipalities, they found that they think it's going to be a way to short circuit the federal oversight and the requirements, which often can be very expensive. But on the contrary, they found, depending on who the judge is who's overseeing this consent decree, it's a recipe for very intrusive and perpetual federal oversight until the court finds that there's been substantial compliance with what is typically a very long document. How does that apply to Colombia? So the administration is basically saying, sign here or else. The or else is, we will sue you. I'll get back to that in a moment because I think it's different here. But sign here or else, and you're agreeing in this document to a number of things that would be fleshed out much, much more. But basically, you're agreeing to change your admission practices, which we allege have the improper use of race. No court has found that, mind you, and the Supreme Court has ruled clearly in the Harvard case, here's what you can do and here's what you can't do. So presumably, the administration is saying, even though you comply with the letter of the law, we think race is sneaking in and that needs to change. Likewise, there are certain departments that have gone overboard in their in what we think of as anti-Semitic pedagogy. Some departments at Columbia appear to be, some individual teachers saying questioning Israel's right to exist and, things that seem beyond the pale, even in an academically free environment. And we want to have, or the judge to oversee, some control of your viewpoint diversity, by which they mean we want there to be more opportunities for conservative teachers and conservative courses. Now, Columbia has said, Harvard has said, many schools have said, we kind of blew it last year, and we did permit things to get out of hand with the demonstrations in favor of Gaza, which turned an anti-Semitic bias and in ways that we're dealing with. And typically what would happen here, it happened with the Obama administration. They sue them and enter into direct agreements. You're going to do this, that, and the other, right? And the universities say yes. And this is what Harvard said in its lawsuit. We've made changes, real changes. Look at the changes we've made. Here, though, the administration is saying, that's not how we're going to go. We're going to sue you. If you don't sign this consent decree, the suit's going to go forward. It's going to go forward for years. There's going to be depositions, and they're going to be embarrassing. You might have seen a few weeks ago, the interim president of Colombia, Claire Shipman, said some things in stepping down to sort of seemed like cover her butt in her own deposition, that Colombia is up in arms about, saying, no, that's not us, etc. But the federal government is saying, we're going to depose, we're going to do all this stuff. It's a little unclear, but they're trying to say, while that's happening, you are going to not be getting all kinds of money. We will provisionally take it away. And then at the end of the day, says the federal government, you're going to get found anyway to be doing these legal violations, and a court's going to order at our behest the same kinds of penalties. So we're just, cutting to the chase and making it easier and lower profile for you. However, in the police area, you have a really long established pattern of law that says when police are doing, very specific chokeholds and absence of training, etc., there's a constitutional violation. Here, the Trump administration is on untrod legal ground. They want to go in and say that Columbia, in its race admission practices, in its academic, treatment and offerings for students, are violating the law, the Civil Rights Act, presumably, and Title VI, the education provision of the Civil Rights Act. And the very strong counterpoint is what Harvard is making. Basically, this is First Amendment stuff. We're a university. You can't tell us what to teach or how to admit students, provided we are complying with the law. We'll hear you out, and if we agree there's a problem, we'll try to change it and, serve it up to you. But you can't just commandeer us in this way and take over the university. So that, rather than the more tried and true path that happens in police brutality departments, is what is in the offing. And I'll just say it's a much, much murkier road. It's not at all clear that the administration would successfully win this case. And there's very strong counterpoints in favor of academic integrity and independence. On the other hand, as with so many of these moves against big sectors of civil society, universities and media and law, the administration is trying to make an offer they can't refuse, in the sense that while they are fighting this model, they could be really sacrificing a lot of money. Harvard's ready to do that, notice, and Harvard has sued aggressively. They are the plaintiffs, to try to bring this to a quick head. Columbia is faced, and apparently their board is really roiled and divided, with at least the threat of, we'll sue you, we'll take you through the ringer for years, and then you'll lose. Seems to me, based on current law and practice, which never has used this model for universities, they are, if not bluffing, really playing their hand very aggressively, is the administration. And we'll see if Columbia capitulates. If they do, it's a whole new model that could be applied widely and could really change the independence of untold numbers of academic institutions in this country. So stay tuned to see how Colombia handles and plays this hand. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.